Hello and welcome along. And this time we'd like to help you with the process involved if you want to evict a tenant. My name's Andy Haynes. I'm delighted that I'm joined by Kristy Ainge, and she is a senior associate solicitor at Bradley Haynes Law. Welcome along, Kristy. And there's four things I think I want to talk about today, if that's okay. And we'll try and do it in this order because I think it follows a flow of what is the process involved in evicting a tenant. And then maybe we could look at how you would issue the proceedings to make that happen. And then we can move on to, if you have to go to court, what to expect and what that process could be. And then maybe we get our property back, what we should be doing if we want to enter a property. And then maybe a few more questions that sort of flow as we go through that, if that's all right with you.
Absolutely fine, yeah.
So let's start off then with that process of evicting a tenant. And I guess there's two things here. One would be a no-fault eviction. In other words, the tenant's done nothing wrong. You just want to take your property back. But of course, the other side of the coin is if the tenant is not paying or you want to, for whatever reason, get them out of the property because they're not suitable for other tenants. How would you go about evicting a tenant?
So for a non-fault eviction, as you just said, that would be a Section 21 notice. And that just means that the landlord, for whatever reason, wants their property back and they don't have to find a fault on the tenant's part. You'd serve a Section 21 notice, giving a minimum of 2 months' notice. You can't serve a Section 21 notice within the first 4 months of a tenancy. So you have to wait at least 4 months before you can serve that notice. And you can then put it to expire at least 2 months after the fixed term of the tenancy. Or if the tenancy is on a periodic basis, i.e. You're not in the fixed term anymore, you have to give at least 2 months' notice. The other part is the fault eviction, for example, not paying rent, and that would be serving a Section 8 notice on your tenant. And the notice period for those notices depends on the reason for eviction. For example, evicting for rent arrears will be at least 2 weeks' notice, where the rent arrears are 2 months or more. And other reasons are such as damage to the property, causing a nuisance to neighbours, and other things like that. So it depends on the reasons as to the length of the notice.
Now, they're talking a little bit about changing Section 21, maybe doing away with it. What's your thoughts, if that should go, on just using Section 8 alone?
I think it depends what grounds are brought in to bolster the Section 8 notice. But I do think it's clear that a landlord should be entitled to get possession of their property if they do need it. So, for example, if the landlord suddenly runs into financial difficulties, or they just want to move back into their property, or need to sell it, there do need to be sufficient provisions in the Section 8 regime to be able to enable the landlord to get their property back, because there might well be very good reasons as to why.
So maybe then Section 21 might get scrapped, but maybe they will then change the sections within Section 8 to maybe allow the owner of the property, who's the landlord, to get the property back under certain circumstances.
I would hope that's going to be the case, yes, because I think the landlord, at the same time, I can see the protection required for the tenants. At the same time, the landlord does also need that protection if their circumstances do change and they either need to sell the property or move back into the property.
Now, of course, if you want to serve a Section 21 or a Section 8, there is a set process that you've got to follow. Maybe if you don't follow the right process, everything gets thrown out at a later stage. You've got to start again. So I want to talk about that section, if we can, please, Kristy. And in particular, also talking about if let's say my tenancy starts on the 15th of the month, do I need to have the notice from the 15th of the month, or can it be served at any time during that particular month?
So it no longer matters when you serve the notice. So just because the tenancy starts on a specific date, it doesn't have to be the notice correlates with that. In respect to the Section 21 process, you have to have served certain documents at the start of a tenancy, such as the EPC certificate, the How to Rent guide, an up-to-date gas safety certificate, and also if there's a deposit, the deposit certificate and prescribed information. If a tenant hasn't been given those documents at the outset of a tenancy, landlords shouldn't worry. You can still get possession, but they need to be served on the tenant before you serve the Section 21 notice. It's slightly different with the deposit information. If you haven't served the prescribed information on the tenant within 30 days of registering the deposit, then the landlord can be liable to certain compensation payments to the tenant. So that's vital that landlords do that and get the right advice at the start of a tenancy. With the Section 8 notice, there's no prescribed requirement to serve those documents at the outset of the tenancy because you're relying on the tenant's fault. So if those documents haven't been served at the outset, such as the EPC, How to Rent Guide and Gas Safety Certificate, then a landlord doesn't have to serve those before serving the Section 8 notice.
I think there's many landlords that sort of had the tenants in the property a long time ago. And I know things have changed over time with regards to the right to rent and all the other checks that you now need to do. For example, giving out the EPC when someone moves in and checking the smoke alarms. If the tenants live there that long, is there anything to worry about when we do maybe have to move to going to court or issuing proceedings, that we need to panic that maybe it'll get thrown out because of something that we didn't know we had to do in the first place wasn't done?
I think as long as you check the regulations at the time that you serve the notice and you check the tenancy agreement and you serve whatever you think needs to be served, I don't think there could be any criticism, but that's something we'd need to look at when we get the documentation from the landlord and just check when the tenancy agreement was entered into, what was the requirements at the time, what requirements have changed, and if necessary, we can touch all bases and do whatever we think we need to before we get to the court.
Now let's talk then about issuing those proceedings. And is it something that's easy for us to do, or do we need to get a specialist like you?
So I would recommend getting a solicitor to issue the proceedings, just because it's an expensive process in respect of even the court fee alone is £355. And if you don't fill in the documentation right and you don't send what you need to the court, it could be a wasted time and money. Especially get specialist advice so the solicitor can not only issue the proceedings but review the notices, review all the contract documentation, and also include potentially any guarantors. Because if you can't recover the judgment that you're ultimately going to get for any rent arrears, for example, against the tenant because they haven't got the money, you've also got the option to get the guarantors in on those court proceedings. So at the same time as getting a possession order for the property, you can also get a judgment for the arrears against the tenants and also any potential guarantors. So I do think it's best that landlords invest that little bit of money to instruct solicitors to ensure the process runs smoothly.
And of course, the court fees could change at any time as to what you might need to pay. And there's a process, I'm sure, if you send out a letter, is that normally enough for people to get a little bit, not scared, because we're not scaring them, but there is a process. They need to be paying the rent or whatever reason that they're not, you're needing to evict them from that property. Is that normally just enough to have those letters served on them rather than going to court?
Yeah, ultimately that's the first place we always start. Some landlords do come to me and say, I just want a letter going to my tenant. I don't want to serve the notice, in which case I'm happy to do that. But I do think serving the notice to give that intent to the tenant that this is what we're going to do, at the same time the clock's starting ticking on the period, then sometimes it's enough for tenants to sit back and think, oh, I'm going to lose my home that I've been in for 5, 6 years or however long it's been. And maybe it will open up conversations between the landlord and tenant. But on the other hand, in my experience, if a tenant is waiting to be rehoused by the council because they can't afford private renting anymore, the council do tell the tenant to stay there. So I also give the landlord the advice that that's my understanding of the situation. And unless you're going to push forward with proceedings, the tenant isn't going to leave, because tenants have told me that the council has said to them, as soon as you leave the property, you're not a priority when we rehouse people. You need to stay there. So unless that process is started and is gone through with, a lot of tenants won't leave if they're relying on the council to rehouse them.
So what we're saying is that we need to go through this process potentially, and even go to court, and even get to the stage which we haven't yet talked about of getting a bailiff to help you to evict them before they will look to get housed by the local council.
Yes, yeah. I mean, I do get a lot of tenants, and I do feel sorry for some tenants because ultimately their financial circumstances have changed. They've lost their job, they've split up with their partner. And when they go to the council for that help, the council unfortunately say to them, well, you have to stay in that property until the bailiffs are there, because if you leave at any point before that period and the bailiffs at the door, we will not rehouse you. You won't be our priority. And I think they do that to try and get rid of some tenants along the way because there isn't enough housing. But on the same hand, I do think it's wrong because they're then opening the tenants to a huge judgment against the tenants for rent arrears and solicitors' costs, which isn't going to put the tenant in a good position when they're ultimately trying to find other housing and trying to secure jobs, and they've got judgments against them. So I understand the council's reasons because there's not enough housing, and I think some tenants do drop off along the way. But ultimately, I don't think it's fair and in the right interest of those tenants that have to stay in the property, because they're open to a huge amount of stress from the landlord and their solicitors, the court hearings, and also ultimately at the end, they'll have a judgment against them for quite a large sum of money.
And so let's just explore that a little bit more if we can, and we'll come back to the process of evicting someone in just a few moments. Because let's say that whatever reason they have left, they've been to court, the bailiff's been round, they've got to leave the property there and then. The council are then in a position that they will find some kind of home or housing or hotel. Is that the process then that they can start to get back on their feet?
I believe so. I don't get involved after the bailiff eviction, other than sometimes advising tenants on landlords on their belongings that have been left at the property. So I'm not really too familiar with the council's procedures and whether it changes from different districts and different councils. But yeah, certainly I think once the tenants are evicted by the bailiff, and most often they're not there, the council will then rehouse them, and that's when they can start to get back on their feet. But ultimately, that tenant still has a judgment against them, and it's up to the landlord whether they try to enforce that judgment.
So I'm guessing, should they have been given the guidance to stick in the property as long as you possibly can, because they then are not a problem to be rehosed because they've got a home, a roof over their head at that time. It's just a process that they're going through in order to be in that position sometime in the future to be housed, and hopefully there'll be some available properties for them to go and live in. You just got to sort of play a game, really.
Yeah, unfortunately, and a lot of tenants get very stressed about the whole thing. But that's the way the council have to run these things, because there just simply isn't enough housing.
And there is two sides to the coin. Of course, we want to be socially responsible for tenants or where they're going to live next. But of course, they have put themselves in that position, maybe not intentionally, but they're in that position by not making, let's say, a rental payment. And of course, the landlord is running a business. They want to be able to get the rent, to be able to pay the mortgage, to be able to pay for the maintenance, to be able to run a business. No company can actually run if they haven't got enough funds. And it might be the trigger that means that they lose the property anyway, which is going to make the tenant homeless. So I can understand why the landlord might want the tenant who may not be paying to move out of the property. Let's go back then, Kristy, if we can, to that process, because we got as far as issuing the proceedings. We talked about paying a court fee. What happens when you go to court?
So you go to court, and the process has just reverted back to how it was pre-COVID, because there was further steps introduced as part of COVID-19. But I'll go back to how it was then and is now. You go to a court hearing, you appear before a judge. 9 times out of 10, I find tenants don't turn up because they do want the possession order to show to the council. And ultimately, a judge will ask you to go through the paperwork, tell them what the date of the tenancy was, tell them about any deposits, go through the notice, when it was served, the notice period, the ground, and how much arrears were due at the date of the notice and how much arrears were due at the date of the hearing. And as long as the judge is satisfied that all the paperwork is correct, which they will have had before the hearing to appraise himself of, and also that there are no other reasons why a possession order hadn't been made, they will make the possession order that day. The tenant does have an opportunity to file a defence, or they can make representations at court, most often through the on-duty solicitor at the court that day. And really, unless there's allegations of severe disrepair in the property, which have been reported to the landlord, which the landlord hasn't carried out, it's very rarely they'll be able to defend, particularly a Section 21 notice and a Section 8 notice if there are a large level of arrears owing. So if the court's satisfied about that, they will make the possession order.
We talked earlier that you can start the process when there's 2 months arrears happened. Is it true that then if they make a part payment, or maybe just one of those months, so they're no longer 2 months in arrears, that even though we're going to court, all that now has to start again as a process?
No, that's not entirely correct. There are different grounds within Section 8. So you've got the Section 8 ground 8, which is at least 2 months arrears owing. And then as a fallback position, you rely on ground 10 and 11, which are that arrears have been persistently delayed, the tenant's delayed paying rent, which is accumulated to the arrears, and the other ground is that there are arrears at the date of the hearing. So if there's at least 2 months owing under ground 8, then the judge has no discretion whatsoever. They have to order possession. If the tenant has paid off a little bit of rent to bring it to below 2 months at the date of the hearing, then ground 10 and 11 are what are called discretionary grounds, and the judge has a discretion as to whether or not to award possession. So, for example, if the tenant has been able to pay quite a bit towards the arrears by the date of the hearing, and they come to court with a payment plan and explain how they got into that mess and how they're going to get themselves out of it, then sometimes the judge will be asked to order a postponed possession hearing on the basis that as long as the tenant picks up with their rent and they catch up by a certain date, then they won't order possession. This is a way to try, and obviously no one wants a tenant to lose their home. Ultimately, a landlord wants a tenant to remain in the home, particularly if they're looking after it. So yeah, grounds 10 and 11 are discretionary, so the judge does have discretion. So it depends what evidence the tenant can bring up at court as to how they're going to catch up with those arrears by a certain date.
And we're talking 2 months arrears. So let's say that the payment is due on the 1st of May. Is it true that then they are 2 months in arrears by the 2nd of June? So they've missed the 1st of May and the 1st of June's payment. That means 2 months, not necessarily 2 calendar months.
Yeah, it depends whether the rent payments are in advance. So yeah, if a payment is due on the 1st of May to cover May, or on the 1st of June to cover June, as soon as those payments are due, they are in arrears as at the 2nd of that month.
So let's then start to think about the judge then ruling in your favour, and they do agree that they do need to leave the premises. What's the timescale after that that's likely to be granted by the judge before they move out?
So the usual possession order is 14 days. You can ask for forthwith in extreme circumstances, but it's very rarely given just because it's a bit unfair on the tenant. So the usual order is 14 days. However, the tenant can plead to the court for what's called exceptional hardship. If they can prove to the court that they will suffer exceptional hardship if a 14-day possession order is made, they can ask the court to order up to a maximum of 42 days to leave the property. But they do have to prove exceptional hardship. It's not just because, it's not enough time for me. Some examples where the courts have considered this is if they've got health conditions, or their children have got behavioural problems and they're suffering at school, or emotionally or their mental health suffering. And in those situations, sometimes a court will consider a longer period, but the maximum they can give under the legislation is 42 days.
And whatever time does get granted by the judge, what's then the process if they still don't leave?
So if at the date, so say the judge makes a 14-day possession order, and that's from the actual date of the hearing, on the 15th day, because they've got until the end of the day on the 14th day, I will tell my landlord client, just drive by the property, see if they're there, try and ring the tenant. If it's clear the tenant's still in the property and they haven't left, then they need to apply to the court for what's called a warrant of possession, which is effectively making an appointment for a bailiff to attend the property and evict them.
And so the process then of the bailiff coming in, is that a quick process that you can get a hearing at the court? And how long would it take the bailiff to evict them?
So there's no hearing for a warrant of possession. You apply to the court for the warrant of possession, and then the court then write to you with an appointment time. Usually it's around four weeks. It depends how busy the courts are at the time. And at the moment, with all the COVID backlog, I think it's starting to settle down a little bit now, but usually around 4 weeks. They'll write to you with a time and date. I will then check with my landlord client whether that's suitable, because they would need to be in attendance. We would then write back to the court and say, yes, this date and time is acceptable. And then they'll then write to the tenant and confirm with us as to the date and time of the eviction. And then on the date of the eviction, whenever that might be, I advise my client to turn up with the keys, with his ID, and also with the locksmith, because it's very important that you get a locksmith there on the day to change the locks.
And the bailiffs will make sure that they leave immediately, then the property is back in your possession.
Yeah, so the landlords the bailiffs can use reasonable force. I think more times than not, tenants have already gone that morning. because I don't want that confrontation. So yeah, I've never had a problem where tenants haven't left on the day of the eviction. Landlords change the locks and the properties back in their possession.
So now you got your property back, the tenant maybe paid a deposit in the first place. Is it okay to use that deposit to pay off any arrears and indeed to pay off any damage?
You will already have a judgment for the arrears, hopefully, when you've got the order for possession. So you've already got that judgment. What I advise landlords to do is assess the property, look at how much damage has been caused, and then ultimately you need to go through the Deposit Protection Service or the TDS, whoever the deposit's registered with, put your case forward as to how much of the deposit you're going to retain, and then they will liaise between the parties and come to some sort of resolution. So it's important you do it the correct way. I tend to, I don't really advise my landlords to take the deposit for the arrears just because they've already got a judgment for that. They can enforce that. So if they've got any damage, they can then put their case to the DPS or the TDS and then get any of the rent back towards the damage. And then, of course, if there's some money left in the deposit pot due to the tenant, you can then say, well, we've got all these arrears as well. We've got a judgment for this. Well, I want the rest of it, because 9 times out of 10, landlords don't enforce their judgments against the tenants because tenants who aren't paying rent generally don't have money.
And what about if they leave items in the house? Are you allowed to dispose of it? And who pays for that?
You can't. I'd advise against disposing it. If it's general rubbish and waste, then yes. But if the tenants have left property such as TVs or clothes or any antiques, jewellery, then it's important that you do it correctly and follow the correct procedure. You revert to the tenancy agreement and see what clauses are in the tenancy agreement, because you could become what's called an involuntary bailee of the goods. And you may need to serve a notice under the Torts Interference with Goods Act. So it's important that the correct procedures followed. I'd advise landlords to take pictures of any goods that have left in the property, because even though you've followed the procedure that you should do, you don't want a tenant coming back to you and saying, I had an antique that was worth thousands that you've sold or you've got rid of. So if you take as many photos as you can of everything that's left, you'll use your reasonable endeavours to try and contact the tenant to return those goods, then it puts you in a lot better position as a landlord. But you should get advice and follow the procedure that you need to do.
So that's the process for evicting a tenant. I'd just like to talk finally about some variations on that, if that's okay, because it could well be that the tenant's not paying. You've done a drive-by, they're not there, and you want to maybe serve a Section 8 or Section 21. But how do you know whether they perhaps abandoned the property and are not coming back?
The best way to ensure tenants abandon a property is when they give you the keys back. Very rarely happens. The other thing I tell landlords to do is drive by a couple of times, maybe different times of the day. If the cars are there, if the curtains are open, or if they're shut, there's lights on and it's clear that someone is in the property. I also advise landlords to just speak with neighbours, because most often than not, they do know neighbours. So just speak to neighbours, ask them if they've seen the tenants around, if they've spoken to them, if they've seen any removal vans. So you can get a lot of information from neighbours too. It's also a good idea just to check with the tenant. So give them a text or a call, as long as they're not consistently doing it, and then you can be accused of harassment. You have to avoid that. So as long as you're not consistently contacting the tenant hour after hour after hour, day after day after day, then at least make 1 or 2 phone calls or texts just to say, hey, have you gone? Because some tenants don't make it that easy for landlords. But yeah, certainly I'd go to the property, knock on the door at least just once, just check lights at night time, curtains, and speak to neighbours.
And if you've got a property where you want the tenant to go, the tenant knows that eventually they are going to be moving out. How acceptable would it be for maybe a landlord to go up to that tenant to say, look, I know you're in arrears by 2 months. I'll write that off. By the way, I'll give you a certain amount of money to move out by next week. Would that be allowed?
Absolutely. There's nothing to stop that happening. And most often I do say to the landlord, if you have a chat with your tenant, it might be that realistically you're not going to get those arrears back anyway. You're going to spend a huge amount in court costs. If your tenant's happy to go, if you write the arrears off or even offer them a small amount short of what you'd pay in legal fees, it's certainly worth doing. And it's up to the tenants then to get that advice and leave. But as I said before, if they are waiting for the council to rehouse them, a lot of tenants won't accept that because ultimately they're not going to be able to afford the private rental.
Kristy, it's been so informative today for so many landlords, I'm sure, for helping them to safely evict people. There's all sorts of reasons why somebody might want tenants to leave a property, but of course, however you do it, it's about doing it safely, it's about doing it legally, it's about following a process, no matter how difficult it might be for you and emotionally charged it might be for both you and they. It's important you follow the process and stay calm and help it to be that safe process. Kristy, thank you so much for your help today. How can we contact you?
So you can contact me at Bradley Haynes. My email address is kristy@bradleyhayneslaw.co.uk, or call the main office number and I'll get back to you as soon as I can. And I'm happy to have a free initial chat with any landlord or indeed any tenant that's in difficulties and see if we can find a way forward.
Thank you, Kristy. We'll be speaking to you again soon with more in this series of how to help landlords in their property journey. Thanks for your time today, Kristy. We'll see you soon.
Bye.